Hello and welcome to this bite-sized Astranti financial training video. And today's video is preparing you for your BA4 exams because it's going to tell you everything you need to know. Well, it's going to give you a brief flavor of the terms you're going to come across that are associated with contracts. So in this short video, you're going to learn all that you need to know. Congratulations! Congratulations for what, I hear you ask. Well, I'm delighted to tell you about your new car. Well done. It looks wonderful. This is the new car that you've just bought up from your local dealership. And here is your dealer looking very happy and slightly triangular. And one of the reasons you bought your new automobile was because the car dealer told you that the car had alloy wheels. So you drive home even happier than the car salesperson themselves. But what's happened 3 weeks later? You realize that your car doesn't have alloy wheels, and in fact it is starting to rust. Now of course you won't settle for this, so what you have to ask yourself was whether the car having alloy wheels was in the terms of the contract that you signed. If it is, you should be able to sue the seller for breach of the original contract, and then you will be awarded damages. However, if the alloy wheels were not in the terms of your contract and they were only a representation in the contract, then you would be less likely to receive compensation. Oh no, it's a terrible bind. But the statements that we started to begin to use during the course of a negation are called contractual terms or representation. And what a lawyer's job is to do is to distinguish between whether it's a representation or an actual term of the contract. Now, I've been banding around these terms, representation and the contractual terms, and I think it's probably time we get a better understanding of what these terms mean. So let's have a closer look at what representation actually means. Well, I put a definition of sorts on screen for you, and of course it reads, a statement of fact which the receiving party relies on and encourages them to enter into the contract. Now here we'd find that the representation is normally given before the contract. Well, that makes sense, doesn't it? Because it's a statement of fact encouraging someone to enter into a contract, so you'd expect it to come before. But it can also be repeated in the contract itself. Now, of course, you can't go around just saying anything you want, any statement of fact to encourage someone to enter into a contract, because if you make false representation, then the other party is liable to claim misrepresentation. So let's use our example of your car, I should say. Now, we know the issue was the wheels, don't we? And if the salesperson told you that the model of the car that you bought was designed with alloy wheels, then that is representation. Because it's saying this is a statement about the model of this particular car. Now, it's slightly different if the salesperson says that the actual car that they were selling them had alloy wheels and it didn't. And this would be misrepresentation, and they would be able to make a claim against the seller. So we can see the car was designed with alloy wheels. It's a statement of fact. Not necessarily saying that this car you're buying has alloy wheels. However, if the salesperson says this car has alloy wheels and it doesn't, then that's a misrepresentation. It's not factual. And of course, as we saw, representation has to be a statement of fact. So there we go. We've looked at now what is representation. Let's move along now and actually have a look at what are contractual terms. And again, I'll put a definition on screen for you, because any provision forming part of a contract and any breach of this provision could lead to litigation. Now, what makes things tricky is that not all terms are expressly stated. In fact, some terms have less legal emphasis than others because they may be not so central to the objectives of the contract. Now, it's really important to know whether a statement is a contractual term or a representation because each one leads to a different course of action. Let me give you an example. Let's imagine, for instance, that we're dealing with a statement that is a term of the contract and it's not fulfilled. What do you think would be able to happen? Well, in this case, the innocent party would be able to sue for a breach of contract. But if in fact the statement isn't a term of the contract, but is instead a representation which turns out to be untrue, just like our alloy wheel example a moment ago, then instead the innocent party would bring action for misrepresentation. So we've got two different courses of action based upon whether it's a term of contract or representation, and in each course of action there is a different remedy. And just to give you an example of a term of contract, let's bring back our car example. And let's imagine that the contract described the car as having alloy wheels. That would be the term of the contract. This car has alloy wheels. Now, if the car didn't have any alloy wheels, we see that is a breach of the contract because we can see it's a statement that's not been fulfilled. Okay. So the court looks at 4 different points when considering whether a statement is a term or indeed a representation. So let's get those points on screen for you first, the 4 points that decide whether it's a term or representation. We've got the parole evidence rule, the importance of statement, time, and relative expertise of parties. So let's have a look at the first one, which is the parole evidence rule. And what the parole evidence rule suggests, it's only the terms included in the written document are actual terms. Any verbal statements made alongside are representations. So if we think back to our car example, the buyer or you, let's keep it with you. You signed the contract for the car. Anything that the salesperson said to you verbally is a representation. So if the salesperson says, yeah, this car's got alloy wheels, verbally, it would be representation unless it's written in the contract when it become a term and then the salesperson would have breached the terms of the contract. So verbal would be representation in this case. If it's written in, it would be a term of contract. If it's written in and it's not true, they've breached the contract. If it's verbal and it's not true, it's misrepresentation. However, then we move on to something called the importance of statement. And this is when the statement is so important, it makes something a term. So let's say, for example, we have the representee. So the representee in our car case would be the seller. And they said to the representor, which in our example would be you, the buyer of the car. Now, if they said, now this car that you're buying is so much better than all the others because it's got alloy wheels, and that alloy wheels became a major selling point, a major reason why you bought the car, then it may become a term rather than a representation. And that's due to the importance of the statement. It's from which everything else hinged. But we also have to consider time when we're looking at whether something is term or representation, because the longer the period of time between the statement and the contract being signed, the more likely a court would consider it to be a representation rather than a contract of term. So let's imagine you're going back to the car garage and you went this time last year and the car's still there, which probably isn't a very good sign, but there we go. And you think, I still like it. I remember the salesperson told me it had alloy wheels, so yep, I'm going to buy it. Well, because there was such a long period of time between the statement and the contract, it would probably be more likely to be considered a representation. And the final point, the final 4 points, whether a court would consider something a term or representation, is relative expertise of parties. And perhaps this is unsurprising because what it does, it looks at the expertise of both parties. So let's imagine that the representee, the seller in our car case, was an expert in cars. And you, the purchaser, doesn't know anything about cars, never bought a car before, you're a total novice. In this case, it would be more likely, or the court would be more likely, to see the state of alloy wheels as a term, because it's the expert making that statement. But if we flipped it the other way around and said, well, actually the seller is the novice and the purchaser or the representor is the expert, then the court would be more likely to see the statement of terms of alloy wheels as a representation. So there we can see the 4 different points of whether a court decides on term and representation. We can see that it can fluctuate quite a bit and takes into a wide remit of ideas. So let's move on. And why is it important? Why do we even care? Well, we said, didn't we, earlier, that there's 2 courses of action on a statement. One way is for a breach of contract, terms of contract, and the other way is for representation. So obviously, there's different causes. It's important because you have to know which one to take, and also each one has a different impact. Because each misrepresentation and breaches of contract are treated differently. And they're treated differently based on a number of reasons. And the first is the time frame which claims can be applied. The second is the right to terminate a contract. Now, in the right to terminate a contract, it's much easier in the case for misrepresentation. So obviously, it's really important to know whether something's a misrepresentation or breach of contract, because, of course, it makes it far easier to terminate a contract, which is really important. And it also differs in regards to damages. For breach of contract, the claimant would be put into the position they should have been if the contract had been properly performed. With misrepresentation, the claimant would have been put back to the position they were before the contract was agreed. Because remember, we often talk about representation happening before the contract. So they don't lose anything, they're just put back to the situation they were in before the contract was agreed. And it's not to say misrepresentation or breach of contract are worse off or better off than each other. It really just depends on the circumstances of each individual case. So there we go. Thank you very much for watching today's bite-sized video on contract terms. Hopefully that's going to be everything that you need to know so that you are going to ace your BA4 exams. Good luck with those. And if you want more of these bite-sized videos, be sure to like and subscribe to our channel. Thank you so much for watching and good luck.